everybody for joining us today. We're really excited to be here with HPfid and Mitigate Partners, so we appreciate you guys attending today. The topic is really how to leverage CAA transparency and your fiduciary process to pay less for healthcare, which I assume everyone on this Zoom wants to do. I want to share a little bit about Mitigate Partners very quickly. Mitigate Partners is a national alliance of independent advisors stretching from Portland, Maine to Viva Las Vegas, Nevada. And we're focused on creating employer-built healthcare plans with better benefits and lower cost. We collaborate together to solve the challenges, share best practices, and really develop resources to serve our clients across the country. We believe that 1 + 1 = 20, which is why we all formed and share ideas to the betterment of our clients. And lastly, we deliver healthcare that works, and that's what counts. So let me go ahead and share with you for today what's in this for you and what we're going to be talking about and why you should care. So number one, you will be able to understand your fiduciary responsibility and why it matters. You'll be able to get more details on your data, on your healthcare plan, and make better decisions for your plan participants. And lastly, be able to save money and deliver better benefits for your most important asset, your people. And this is the bottom line. Activated fiduciaries pay less for healthcare. So without further ado, I'll introduce you to our speakers today. Christy Gupton will come on at the end. She's a Mitigate partner in Morganton, North Carolina. She'll be on at the end to handle the Q&A. But to start with, we're going to start with Tony Sorrentino, Director of Compliance for HPfid, and also with Drew Kalistad as well with HPfid. Y'all take it away.
Excellent. Thank you very much, Carl, and welcome everybody. Thank you, Mitigate Partners, and for everyone that's investing time today to learn more about the CAA, and particularly what it means as a fiduciary of a to be a health plan sponsor of an employer health plan. So our first slide here, I'm Drew. Of the two of us, Drew and Tony, I'll be covering most of the slides. Tony will be talking about some of the legal side. So Tony is our Chief Compliance Officer, ran a benefit shop for 32 years. He is a Creighton adjunct professor on health plan ERISA compliance. I did the same thing. So between the two of us, we were benefit advisors. Now we run and lead in HPfid. We launched a few years ago, seeing the CAA coming. So there's a little bit about who's going to be talking to you today. The phrase I had on the first slide called status quo, I want to share with everyone because we often say that in our lives, but we maybe don't know how it translates into healthcare. So in the Oxford definition, and it's very tight, the existing state of affairs, especially regarding social and political issues. And there's an example. They have a vested interest in maintaining the status quo. So that's a powerful tee up. So there is, in healthcare today, the stakeholders, on one side of the ledger, there's some very large and entrenched stakeholders, you know who they are. And so things are going rather well for them. Employers and employees, not so much. And so there's really two stakeholder groups, and those that are winning are in no hurry to change that. All right, that's important. That's what this force of status quo is. So with that being said, next slide, please. So big picture, these are elements here. Healthcare is unaffordable. There's a lot of people that cannot afford high deductibles, $5,000 and $10,000. Medical debt's the #1 cause for bankruptcy in the US. I'm not going to read them all, but there are people that we know that have an employer-sponsored health plan that cannot afford their medicine. They cannot afford to see a doctor, and they can't, and then pay the food bill at the same time. Healthcare inflation, 7 to 9% is what's projected. You know, that starts at the 16 or 20%, and then you do the kabuki dance, as Carl says, and you might get it down to 7 to 9. All right, and so that's what happens when we buy healthcare, the way the system is feeding it to us. Okay, so today, healthcare is unaffordable. This is the status quo. Next slide, please. So what problem do we solve for employers? So the problem that exists today has been progressively getting hotter and hotter. It's like, how do you boil a frog? Very slowly, as the phrase goes. So what problem do we solve? There's a CAA law. There's a fiduciary mandate. There are gag clause. There are things you're going to learn about today that you need to do as an employer that fall into what we call the compliance list. But we want you to focus today to realize, if I do what I need to do, this is actually an opportunity. The CAA was created to help you take cost out of healthcare. So what do we solve? CAA Made Easy on the right-hand side. Expert fiduciary guide. Tony, it's basically Tony in a bottle. Tony, we've been working for 2 years, distilling now 35 years of experience into this resource to help you have an easy button for fiduciary process. It's going to save you time and money. It's something you need to do. The law says so. It would cost more, I think, to call an attorney and ask for an hour of advice or 3 than it would be to put together your process here. And last but not least, reduce liability and risk. So there is fiduciary risk if you do nothing. So what is CAA technically? So 2 things happened. Oops. Boom. Healthcare pricing and fee transparency. So the CAA created hospital prices have to be shown in the marketplace, and there's now emerging and very powerful data out there on hospital prices with the big health plans. And transparency of fees also coming in from the health plan side now. So all of the data is out there. It's 20% of our economy. Now we know what things cost. Number 2 is that health plan fiduciaries, that's you if you're a plan sponsor, you need to have a fiduciary process that we're going to see in a minute. Looks like what you do on your retirement plan to help monitor these costs. And we know what happens on the 401k side. It worked. It will ultimately take cost out of healthcare. So technically, that's what the CAA does. Practically, what is it revealed? Transparency is revealing hospital rates are out there. The health plan rates are now out there. So it's all available to you. It's not, you have to go find it. You have to go look, you have to find that data and then learn how to compare it to what you're paying. Transparency is revealing that employers in the commercial sector, anyone that's an employer-sponsored health plan, is overpaying for healthcare, number 1. And number 2, this new transparency is creating an opportunity for you. If you learn how to harness that transparency and that information, either you're going to be a better negotiator or you might find a better way to buy healthcare. So the CAA was created to enable that. Our next slide here talks about the goal with data. So the higher you climb, the better the view. So if you look in the lower left, when you look at a CAA fiduciary process and you wonder, what do I do with data? It looks like a mountain off in the distance and you don't know, how do you climb it? 1 step at a time. If you start getting your data, getting in some scorecards and some dashboards, and then you start benchmarking, what should we be paying for pharmacy by drug? What should we be paying for specialty pharmacy and TPA fees and doctor fees in hospitals for a hip and a knee? All of that is available today. Benchmarking, correlating that, learning and isolating the causes of your cost drivers, predictive analytics. Now, what do we know now that we know this? All right. And ultimately optimization. So the moral of the story, let data work with your benefit advisor, work with Mitigate partners to get a hold of your data and let data get in the way of your decisions. That will help you optimize and isolate cost drivers that are actionable. And the data is out there, folks. It's not, you don't have to wait. It's powerful today. So our goal as a team at HPfid, so it's it sounds like a funny name, but it stands for Health Plan Fiduciary Compliance, hpfid.com. So activated fiduciaries, those are the folks that understand this. So there's a resource you're going to learn about. To become activated, you have to become a little educated and then get on your front foot and get moving. And activated fiduciaries will teach you, your benefit advisor and Mitigate partners will teach you how to harness pricing transparency, harness the law to your advantage. Yes, there are duties. Yes, there could be penalties, but harness it to your advantage and then begin to data benchmark what's happening inside of your plan. Fees, rates, costs, ultimately to remove cost from your health plan. I'll say one quick equation: number of units times cost per unit equals total cost. Historically, the unit cost has been, well, they're taking care of that. We just have to work on wellness and try to use less and less and less. But we know if that worked, it would have worked by now. So now you get the transparency. So the equation is complete. Tony, over to you.
Yeah, to paraphrase what you were saying, Drew, there's now a law that says you have to remove costs. Before it was just a really good idea, and now it's the law. So I think that says a mountain full of information right there. So when we look at what we've got here next, the Consolidated Appropriation Act unlocks transparency, and with great opportunity comes great responsibility. So if we look at the goal of the CAA legislation is to improve transparency in 4 key areas. You can't use information if you can't find the information or you can't see it. So along the top, the number 1 and 2, obstacles removed to be a good fiduciary. So there were, we call it pillars, but there's 4 basic tenets of compliance with CAA in 2023. There will be more in the future. The first one is to remove something we call gag clauses from service provider contracts. What is a gag clause? A gag clause is anything that restricts access to your information. And I want to stress the word your. This is your information. It does not belong to your TPA or your carrier or your ASO provider, whoever it is. You'll often hear a response saying, well, you know, it was yours. And then when we ran it through our adjudication system and applied our discounts, it became ours. That is not a fact. That holds no legal water. That is not true. It's your information. And one of the first steps of CAA compliance is to gather your administrative service agreements, whether that's for your medical information, you could be your PBM, your pharmacy benefit manager, whoever has an administrative role in your plan, you have a written agreement with them, and you need to go through those agreements, or somebody on your behalf needs to go through those agreements and categorically identify each of those gag clauses in the contract. You know, we suggest, because CAA, above all, is an employer law. It mandates nothing of the carriers, nothing of the providers other than transparency. But to get the fiduciary ball rolling, it's up to you as a plan sponsor to do that. So we suggest, you know, getting the process started by using what we call a template letter and reaching out to each and every one of those service providers, telling them that you're aware of CAA. Here's your expectation that you're going to remove those gag clauses, you're going to amend the contract, or you're going to get a new one, or at least tell me so. You stand pat on your agreement. You may say it doesn't have any gag clauses, or you say it does, but you need to know as a plan sponsor, if you're on foot or horseback, what are we going to do? So that's the first step, the removal of the gag clauses. And I'll say this again later, but there's this little thing in CAA called attestation. And by the end of the year, 12/31/23, you have to attest. And what you are attesting to is this step, the removal of the gag clauses from service provider contracts. You're not attesting to the other 3 items we're going to talk about. You're attesting purely to this. The second obstacle to remove is, if you want to call it that, is a disclosure of direct and indirect compensation from all service providers. For 2023, we're focused purely on broker compensation. That's a sensitive topic for me. I was a broker for 35 years, so was Drew. And the bottom line is, we'll be succinct. You've got to disclose it. If you haven't already, you need to do it. Plan sponsors should be asking for this, but you need to be ready to do that. And when we say direct and indirect, you know, we're all friends here. There's marketing objectives, there's overrides. If you don't know what it's going to be, you have to tell them, well, here's what the formula says. And when I do find out what it is, I'm going to tell you. And frankly, this is just being put in writing in 2000 and late 20. It's actually been around since 1978 in the form of a prohibited transaction ruling. So those are the first two things. Obstacles were removed. Expectations of the fiduciary. Now that you have transparency, now that you removed your gag clauses, now that you've disclosed your compensation, we go to number 3, and that's established reporting requirements for pharmacy and prescription drug disclosure. You will have offers from your PBMs to do this on your behalf, or you can do it on your own. What we stress here is, depending on the size of your group, and we're not addressing, 5 live groups today. Let's just say we're larger groups, probably self-funded, but could be larger, fully insured. What you want to do, whether you report this to the government entities or somebody on your behalf does, is to the extent possible to capture your own experience. If you're in a small enough group that it's reported in the aggregate, there may be very little you can do other than to affirm that the information was sent in the aggregate, which is legal. But it's all about your own information, because as we're going to talk about in a few minutes, you need to take that information and benchmark it. And now to the fourth and probably most misunderstood of all requirements, or the pillars of CAA. Required parity in substance abuse and mental health parity. I'm certain all of you know what mental health parity is. I'm certain that you've abided by it in the past. But what the CAA does in 2021, it adds 2 new requirements to health plans' existing obligations under mental health parity. They're fairly straightforward. 1, you have to perform a comparative analysis, which I'll define in a moment. And 2, the duty to disclose this analysis and any related information to the Department of Labor. Here's what's important, 2 words, upon request. Unlike the pharmacy data, this is not something you send in. You do it, you document it, you hold it, and if it's requested, then you have to disclose it. Sorry, a little something in my eye there. So what is the comparative analysis? Well, the good news is none of us know, including the Department of Labor. We've talked about what it might be, but there is no template, there is no format. What we know and what we think is the best idea is to produce some sort of a template in a complete side-by-side comparisons, documenting the processes, the strategies, etc., any standards used for what we call NQTLs, or non-quantitative treatment limitations, against those who are quantitative. Because what the CAA requires is for you to perform and document this comparative analysis of the design and application of non-quantitative treatment limitations. That's all it does. And what does that really mean? An NQTL consists of any limitation on the scope or duration of benefits that are not expressed numerically. I'm looking for subjective things here, not quantitative, like number of days you can treatment or treatment visitation limits. It's convoluted, it's complicated. Whether you do it or somebody else does it, we have tools on our website that link you to a self-assessment at DOL that probably will arise to the occasion of being an affirmative defense. But do it, document it, and hold it in case you're asked. Do I think you're going to be asked? I do not. Doesn't mean you don't have to do it. Those are the 4 pillars. If you recall, maybe in about 15 years ago, back in 2008, the retirement world was rocked a little bit by these same fiduciary obligations. It started off with, you have a 401k, you had to have average deferral percentages and some sort of a discriminatory standard done. It moved on to 408B2, which is a fancy way of saying that parties had to disclose their compensation to plans and plan participants. People got a little lazy. There was complacency. They weren't doing it. Class action lawsuits ensued, mostly over fees. Many plans were sued, and what the result of that was a fiduciary process that now we've gone from about a 6% fee for plan participants down to about a 0.5%. It took a while. There were some parties who were no longer part of that equation. That's going to happen here. It's happening now in the health arena. We'll see regulatory change and industry change. So you see a very similar timeline here. We had the transparency rules for hospitals and providers to post there in a machine readable format what their costs were going to be. Along came the CAA, and that took advantage of the transparency and coverage, which is TICRA as they call it. But here we've sat for 2 or 2.5 years. Most plan sponsors haven't got it. Some of the parties didn't post their information on a timely basis. We've had complacency, and now we're what, 80 days away from having to say, yes, I can comply with the CAA. We've got the dotted line there. That's where we're at. I guarantee you there are law firms, go to LinkedIn, I won't use their name. They're advertising for employees of 10 different companies. Come see us, come talk to us. We think there's a lawsuit. We think you've been damaged. The way to avoid all that, the way to build an affirmative defense is have a well-adopted fiduciary process. That's the compliance piece. But what we're telling you is a little bit of dirt over this pile of gold, blow off the requirements for compliance, and you're going to find a pot of gold. There's a lot of money to be saved. Finally, this next slide will tell you about what the carrier performs versus, let's light up the self-insured, what the fully fiduciary process. We have carriers who are doing prescription drug reporting. They're gathering this analysis on mental health parity. They will tell you that they have no gag clauses in their contracts. They do. They will ask you if they should perform the attestation on your behalf. If you're 100% sure that that contract had no gag clauses, well, then go ahead. If it were me and it were my plan, I'd want to make sure, I'd want a copy of that contract, that administrative service, and I'd want to go through it. And in a lot of cases, they're saying, well, certain data really isn't available. But if you look to the right, that's pretty much if you're fully insured, maybe larger ones could get some data. But if you're self-insured or level funded, here's what you have to comply with. The 4 pillars I discussed. The attestation, whether you do it or somebody else, you have to make sure that the information is correct. A fully documented process. Nobody expects, including the Duell expectations are for perfection. The best network, the cheapest network, the best outcomes. But you do have to document that you made the effort. Activated fiduciary team. I have a team, I have a process, and I own my own data. Those are the things that are going to give you the get out of jail card for CAA. I'm going to turn it over to Drew for a moment.
Excellent, Tony. So folks, before we go forward, questions, there's one coming in now. So this would be a great time. That was a lot, Tony, and thank you. That's just a look into the bucket of the complexity here. So I'm going to read this. We're going to answer it live. So what are the chances the payers are going to provide full data files to fiduciaries, even if gag clauses are removed? So Tony, you want to comment there?
Well, the answer is fairly straightforward, and the law says that the plan sponsor, once they have the information, can make such a request. I want to be 100% clear. Just because the transparency is there, the law applies to the plan sponsors, and they ask, we have no guarantee that they're going to actually do that. What I think is going to be happening is a little bit of a waterfall effect. One of the, I'll call them BUCAs or regional carriers, will begin to share that information. When they begin to share that information, it typically has a trickle-down effect to the rest. Do I think they're all going to share it in the next 80 days? No. Does that relieve you from your obligation to request that? No. Is it 2024? Is it 2025? I think the industry will eventually catch up with the mandate, but it's going to take some time.
Excellent.
Hey, Tony. In a unrelated or in a related question, does the Consolidated Appropriations Act require the carriers to give the health plan data over? And then one person is asking, shouldn't my broker be helping me gather this data? And then lastly, third little element of this, once we get it, then what?
I'll try to answer them in order. Does it require the carrier to comply? No, there is no penalty exacted on the carrier. Again, CAA is an employer law. The compliance penalties, $100 per day per employee without limit, are exacted against them. Could it potentially lead to the plan sponsor, if they were sued for non-compliance by a plan participant, engaging or enjoining that carrier in any lawsuit to share in the penalties? They could, but what we found out in prior legal cases, Massachusetts Laborers versus Blue Cross Blue Shield of Massachusetts, the First Circuit Court of Appeals has said there is no fiduciary obligation on the part of the plan carrier. It's all on the plan fiduciary, who is the plan sponsor. So probably not. Should your broker be helping you? That's a loaded question. I think a broker who is in tune with what is happening and the potential repercussions to their plan sponsors would at least be talking to them. And if they're not a broker who can do this, and there's many who can't, they would be engaging in some sort of a partnership with someone, whether it's HPfid or someone else, to assist their clients in doing this. If I were a broker, yes, I would be helping. And I thought there was a third part of that question, and I might have missed it.
Hey, Tony, so what I want to do here, some great questions, and I want to get through the material. We're planning to finish in about 10 minutes and then have a robust 20-minute Q&A. So I'll read 2 questions for you to pause on, and we'll come back to these folks. But Pat's asking, how do you handle the carriers like recent Cigna stating that they're not sharing attestation and state that they don't have gag rules? So we'll address that. And then if you have a PBM and the PBM had gag clauses in the network pharmacy, not with the plan, are you in violation? So we'll talk about that. So gag clauses in general, yes, you as a fiduciary are not permitted. The law says you can't be party to a contract that has gag clauses that prohibit your ability to be a fiduciary. So we'll circle back. The law is about the plan sponsor. It is not about the carriers. So for a moment, let's pause. We'll go about 10 more minutes of content. We'll come back to those questions, and they're great. So please, everyone else, keep loading your questions in. So back to it here. We believed in 10 years, just like that slide that Scott or Tony narrated just a minute ago, we're going to look back and see the CAA transparency changed healthcare for the better. You can now pay less for healthcare. There is a narrative we talked about at the beginning, the status quo stakeholders, the people, the entities that are making a lot of money right now on healthcare. They are not in a hurry for this thing to change. So just be aware of that. So there's a counter narrative. You need to be aware to be able to push through that. And this is a good thing for you. So next slide, please. So I won't read all of these. You can pick 1 or 2 or 3, but this is either the voice in your head. Oh my gosh, this sounds like a lot. It's renewal, it's Q4. Let's just do what we've always done. Okay, from the upper left-hand corner, status quo is fine. And none of these are true. This is bad. This is what the naysayers, what we're telling you is there are compliance rules. There are penalties someday if you don't do this. There's a reason to do this that's legal, but the reason to do it is to pay less for healthcare, and just recognize the status quo conflict there. So that's the important note here as you read through some of those. So back to you, Tony.
I'm going to jump in. There's been times when I've been given, 5 minutes. Tell me about HIPAA, or excuse me, tell me about CAA. I'm just thinking about HIPAA on a point Drew said. And if I have one slide to do it, this is the one I use. The elements of a sound fiduciary. An employer plan sponsor must do what? They must use their best effort towards accountability by performing benchmarking with documentation to complete the attestation. 5-step process, couldn't be more straightforward. It's not a typo. We put the word knowing, crossed it out, and said, it's one thing to know about it, but you got to do it. Doing this gives your fiduciaries an affirmative defense to enforcement penalties and litigation. And I don't know which is worse. The DOL may be slow to, put penalties on this. They may not be. I know enough as an attorney that I don't want to get in litigation with anybody who's called a plan participant. You don't win those. You might settle, but you don't win. So effort, accountability, benchmarking, documentation, attestation. And remember, you can't benchmark data if you don't have that data, and it needs to be your data. Back to you, Drew.
Excellent. So let's just stay there, Scott, for a minute, please. So this is where we're going to do a little detour. We'd like to just show you a little glimpse of HPfid.com, which is the resource. So all of this about fiduciary process, and still, how do we do this? So if we go to that homepage there you go, Scott. So this, folks, if you went to our website, this is the landing page. If you slide over and you're in courses, we're going down to complete, which is the whole process. Then you come in, we're going to start at the top here. These are resources that you have. So this is 2 years of work and distillation based on 35 years of knowledge and experience and the real new law and what it's meant to do. So these resources here, document templates. You need a letter on the gag clauses. Document library. Let's pause there, Scott, for just a minute. So this is where you go to document your process. So Tony's been talking about the pillars. So on the left of the screen is a file folder construct of all the pieces of your process. And right now we've gone into the gag clause, prohibition compliance. We've gone into your medical plan subfolder. And on the right is where you would store any communication outbound or inbound from your carrier, from Cigna, from whoever there was a question about a carrier. And we sent a letter out. We said, we can't have gag clauses. Are you a good witch or a bad witch? And what email did they send back? What does our contract look like? This is where you store documentation in 23. There's not much time left this year, so it won't be very full this year, but you need to do some things. And if you went down below the pharmacy plan, that's where you document your PBM correspondence, any reporting that happened there, any comments, any meeting notes from your fiduciary meetings. This is where you store each of those pieces. So at the end of your process, at the end of the year, if each of your folders has documents, you now have a documented process. So Scott, let's please go back to the resources section. So at the top, there's more resources above, and then down below here, this is your process. And if we were to click into these, there are 4 to 7 minute videos, and then a step-by-step what you need to do for gag clause prohibition, for mental health parity testing. We have a link that's right there to go to the government to do a self-evaluation. There's a link there to a provider that does mental health parity testing. We don't do it. We don't get any revenue there. We're an independent resource, but drug cost reporting. Your carriers had to send things in, your PBM June 1, and you might have seen some correspondence. This is where you go learn a 5-minute video. What do I need to do? All the way down, and then coming soon. These are the steps for 2023 to position you in 2024 with Mitigate Partners to go take cost out of your health plan. There's not enough time really to shift what's happening between now and the end of the year, but you can spend an hour to get your fiduciary house in order with this process. Thank you, Scott. Let's go back to the slide there. That's a taste of HPfid.com. So here we go. Affordable healthcare is good for businesses and families. And what do we have today? We have unaffordable healthcare. We know what that means. So early adopters will benefit greatly. Do not wait. Do not listen to the naysayers. This is about you. Go get it. I'm a big fan of the Miracle on Ice and the 1980 Olympic team. You were born to be hockey players. Their time is over. Go get this. Don't sit around. This is your opportunity to participate with your advisor, your Mitigate partner, to go take cost out of your health plan. Employers are empowered. You've been deputized. You've been deputized to do this. It's a darn good idea to do it, and you're going to avoid some penalties. Next slide, please. Our mission, folks, and if you feel it, I hope you do. We're here to guide you, health plan fiduciaries. We're not a broker anymore. We don't do that anymore. We're here to help plan fiduciaries with a resource that harnesses your data, the transparency, and the CAA. So your broker can continue to do what they do. Mitigate Partners can help you buy healthcare less. We help you do these things in a process. And if you activate and come on your front foot with your broker advisor. Carl says brokers make you brokers. So your benefit advisor, it's your move. This is your time. Either you sit and it's status quo, or you say, oh my gosh, my participants, they're relying on me. Own your data, change your outcome, embrace the CAA, and activate your process. We have a resource. Whether you use us, gosh, we hope you do. If you don't, use somebody. Do this. Do not let this opportunity go. You're going to find penalties and exposure you don't want someday, but you're going to find the goodness if you do. Next slide. So what to do now? In summary, C-suite executives, HR professionals, engage your team immediately. There are deadlines, 12/31. You have to attest. When you attest, I did something. Okay, you better have done something in your gag clause if you're signing that you did. Partner with HPfid and Mitigate Partners. We're your guide. We're going to help you do what you need to now, what I say is transparency is the flashlight. Our process is your map. Activate as a fiduciary. Activate with Mitigate Partners to go, number one, provide everything you need for a fiduciary process, and activated fiduciaries, they pay less for healthcare. That's our goal. That is our goal today. So that said, I want to say thank you. And you got Tony on the left. You can get a hold of us at info@hpfid.com. Be ready, get details, take care of your people. They're relying on you. And so over to you, Christy.
All right. So many great questions. I'm just going to start with a couple that could be quick and easy one. Here's a term that I'm not even familiar with. Mark asks, is there a private right of action under the CAA? Tony, that sounds like a legal term.
I guess I would have to add a private right of action.
That's the way the question was
Yeah.
typed.
Not exactly sure where that's going. A private right of action.
Well, maybe that's something that Mark and HPfid's team can talk about offline. So
Okay, yeah, I'm not
let's
sure.
keep going. So let's talk about the carriers a little bit. So
Right.
Blue Cross, United, Cigna, Aetna, those are the big household names that 90% of America uses for health plans. Cigna, one of them, has already sort of come out and muddied the waters a little bit and said, we're not going to do this. We're only going to do it in certain circumstances. But even if any of the carriers do offer and end up attesting on behalf of their clients, is there anything that can come back on the employer? And if so, what are the penalties? Do we know that yet?
Right. I'll answer that. The standard line legally is you can always delegate a responsibility. You can never delegate a liability. So if you have some level of trust with Cigna and you want them to attest on your behalf, just know that you've taken care of the ministerial compliance effort for CAA, but you really haven't relieved yourself of any duties as far as fiduciary liability to your plan participants. You need to review those documents for yourself. You don't want a carrier attesting that there are no gag clauses when there actually are, and you made no effort to look. This is very much about effort. This is very much about a process. It's actually less about results. So them offering to do that, some who would be cup half empty people are saying, well, they're offering to do that because they don't want you to look. Some brokers will actually have looked in there and reviewed it and requested some changes. A lot of them don't. Again, you can't offload this to your broker. It's all about you. You need to look.
If I can, Christy, I'll add to that. So the big picture on this, the gag clauses, I want to state again, the gag clause prohibition is that as a fiduciary, you cannot be party to a contract that has gag clauses. In a health plan, there are 3 standard contracts: the ASO agreement with your TPA, the PBM agreement, and a network agreement. Okay, so those three agreements are the legal documents around a health plan. Those have had gag clauses. That is how we got here, and nobody knows what things cost. Okay, those are the padlocks on the black box. Those need to go. All right. So at the end of the day, can a carrier say we don't have them? Yes, I hope they took them out because they've been in there. We've read 50 to 100 and they're in there. Okay, if they've taken them out, and they attest it is the fox guarding the hen house. Oh, we've got these, you're fine, you don't even need to look. So buyer beware. You cannot delegate your liability, and if it didn't go well, you have to, you'll be, the buck will stop with you. So just be aware of that. And the penalties, folks, for non-compliance, for inaction here, $100 per day per employee, no limit. So I had a case in point, a company I work for, 600 employees. We spend about $6-7 million a year on health plan. 6 months of non-compliance at that rate is over $10 million. So I'm not saying that's coming tomorrow, but that's a penalty. Okay. So do this, because now you can get cost out of healthcare. And oh, by the way, enforcement and liability and litigation, you'll be defensible against that.
Very good. Speaking of that $100 per employee per day, does it go back retroactively to the passing of the law, or are we just talking about going forward?
Technically speaking, it goes back. And when we're looking at gag clauses, sometimes you're looking at agreements that aren't really in effect anymore. It might have been back in 21 or 22, and you've changed PBMs or you've changed carriers. Do we know to the extent how much they will word for word literally enforce that? We don't know, but nothing in the guidelines suggests that all past sins are forgiven.
So you said something about changing carriers or changing TPAs. Mark asks another great question. Can the employer sue the TPA for violating the Consolidated Appropriations Act? I'm going to go out on a limb here and say no. It is the plan sponsor's fiduciary duty to choose the right partners to implement and conduct their plan, administer their plan in the way that complies with the law. Did I get that at least partially right, Tony?
I think you got it right. Can they sue? Well, yes, anybody can sue anybody for anything, but the only successful outcome would be is if for some reason that third party, TPA or wherever it might have been, PBM, breached one of their obligations under the contract. There's always, that's a contractual type of arrangement, but suing them for their lack of fiduciary response to their plan participants will never be successful.
Can
Christy,
we
can I
talk
add?
about, I'm sorry, Drew, go ahead.
I'll add a quick note there. So folks, remember the kind of the train track slide that Tony talked about, which had the retirement up top and then had the health plan. So, and there were, as we're moving through time, there is a chapter of litigation. So we're in that chapter today. It's happening. So the lawsuits are out there. There's a very famous lawsuit. We can share a link with you. And it's called the Mass Laborers, where they are, it's a big union. It's a Taft-Hartley in Massachusetts suing their blue healthcare plan. And it took 3 years. And they said, you did this, this, and this, and these are bad things. And then the blue said, yes, we did, but you signed an agreement that said we could. So yes, fiduciaries can sue their TPA, and the judge on this district court and others, they're all stacking up, and they keep putting the onus back on the plan sponsor. You signed an agreement that said they could. They're not denying they did those things. So they did them, they're admitting, but that's not their problem, that's your problem. So it is important, if you review these case law notes and summaries, you start to see what the health plans are doing. Their fiduciary, their CEO, is maximizing shareholder value, which is taking money from our employers and employees. Your fiduciary duty is to protect them. So this is a bit of a battle of fiduciaries. And you can sue them, but at the end of the day, you have the buck stops with you.
Let's talk a minute
Christie-
about, yes, sir.
Could I see a question that I don't know if you're going to pick it, but I'd like to pick it. There's a question from Frank. It says, are municipalities exempt? And the
You
only
read my
reason
mind, Tony.
what's that?
You read my mind. That's the
Okay.
one I was going to pick.
Well, the reason I want to answer it is because we get it every single time. So it's obviously something people are wondering about. So I'll do it in 1 minute. Employee benefit plans established and maintained by government employers are exempt from ERISA's requirements. And CAA is an amendment to ERISA. So it applies to federal or state or local, city, township governments, whatever you have. I always call those quasi-governmental units. But there's a catch. There's two catches. It's complicated because a lot of states, and I am not an attorney in any state other than Nebraska, I don't know your laws, but a lot of them have enacted laws with the intent of establishing fiduciary standards for government plans that are very similar to CAA. Some even more strict, some have been around a lot longer than CAA. So these laws vary by state, and they kind of mirror the protections of CAA, but you've got to look into that with your local legal counsel. I'm exempt from CAA, but it says, because we are a plan that covers citizens of this state, we have to do this and this and this. The other area where you can get into trouble, even though you're exempt, is that a lot of people became self-funded by taking a blueprint from a Blue Cross or a Cigna, and they basically cut and pasted it and did a kind of a lousy job of that and didn't do a real good search. And there's all kinds of references to ERISA. They offer COBRA, which is an amendment to ERISA. They offer HIPAA, which is an amendment to ERISA. They're offering all these other ERISA amendments. And now, by hook or by crook, they fall into the trap of being covered by ERISA because they forgot to remove all these various references. So be careful there.
So I think we've gotten to the point where people need to know what to do next. So let's talk about how much time you think this is going to take to do this the right way.
Drew, you want to take the timing?
I was busy typing an answer, so I was a little off flat-footed there.
We're talking about the timing of what they need to do next.
Oh, perfect. All right. So here we are, folks, middle of October, 12/31 is out there. So your runway is about 2 months. So what to do next, I would say, is go to our website, hpfid.com, and reaffirm this. Go talk to your benefit advisor, understand this. I would take action immediately to begin a process, whether it's with us, whether it's with your benefit advisor, or someone that looks and talks like us. Get that process moving. We hope it's with HPfid. Follow the yellow brick road. Get your fiduciary team put together. First of all, is it 1, 2, or 3 people? CEO, head of HR, CFO, whoever's on your fiduciary plan for retirement is likely. Get the team together. Set 2 or 3 one-hour meetings between now and December 15, and get busy inside of HPfid Complete and start understanding your process. Watch our videos, start documenting what you have, storing it, find the things you need. So all in, it could take you 2 to 3 hours between now and the end of the year to get to a place where you can actually attest in good faith you've done the actions you need to do, and it will position you favorably in 2024 to not only be then an activated fiduciary to continue your process, and there'll be a new folder for documentation in 24. But the step now is get moving, get into hpfid.com or similar, activate your team, identify them, and document everything you're doing. And we have live chat in there that we have ways to contact us if you need help.
Thank you very much for that. We've got a couple of questions that are why questions. Why are we being subjected to this? Tony, you want to take that?
I'll be glad to take it. I guess I would take umbrage with subjected to it. We built our practice on being the shop that was all accountants and attorneys and we knew the law and we didn't have any fancy marketers, but we just knew what we were doing and we worked by referral. I would love to be a broker right now. I would be grabbing broker of records letters left and right. I don't know subject to it. I think it's a gift. Yeah, you got to do some compliance work. But for 30 years, I argue with TPAs and carriers about giving me the information, and I had a carrot. Now I've got a stick. I like the CAA. I think it's good for employers. And of course, it's good for those who consult with them. They can be the hero on the journey. I don't know if you have anything to add to that, Drew, or not. You're on mute.
Sorry again. No, I'll leave it there. I'm answering questions while you're answering questions. So I'll leave that one to you.
Okay, that would be my answer.
So a couple people are just want to clarify one more time. So you already answered our municipalities exempt. You answered that really well. What about nonprofits? What about small, really small employers, maybe under 50? You know, what about this? What about that?
The law applies to all groups covered by ERISA. And technically speaking, that's 2 lives and above that aren't either church plans or governmental units or quasi-governmental units. Nonprofits, typically, not always, there's different kinds of nonprofits, could fall under ERISA. So size doesn't matter in this case. Funding methodology doesn't matter. You can be fully insured, minimum premium, level funded, self-funded, doesn't matter. And to be clear, I got this question. This isn't part of the question, but I'll add it. Somebody asked me, well, if I'm self-funded and I buy specific reinsurance or aggregate reinsurance, is that, do I have to examine those contracts? Reinsurance is not an insurance contract. It's a funding tool. It's a financial tool. So get that out of your mind. You don't have to worry about those guys. But yes, it applies. Is it going to be different if you're in a state like Nebraska where insurance carriers don't have to share information on groups of 50 lives? It's going to be real difficult for you to get your own information and benchmark it. You can't. By state law, and in this case, I'm not getting political here, it sort of trumps, if you will, what CAA is doing. If they don't have to, they're licensed in Nebraska and they don't have to give that information, and they don't have to give that because they can't. Probably community rated or it's pooled, but it doesn't prevent or it doesn't get the employer an out. You still have to request the information. You have to look for gag clauses. You have to do everything. It's just that you're going to be a little bit handicapped. You're going to be kind of handcuffed as to what you can do with it. Whereas a self-funded plan who can get all their information, can do the benchmarking, it's going to be a bigger win for them than it is the smaller group.
Christy, if I can, I'll add to that. So HPfid does have coming soon, next week or 2, a small group. So fully insured, it's a much lighter lift and a much lighter product to help, because the carriers will do some of the reporting, drug cost reporting. They'll do some of the mental health parity. It's a lighter lift, but the documentation and the duty to actually have a process is the same. It's just a little bit lighter lift. So we will have a program soon. If that's where you fit today on this call, that's coming soon. So keep a lookout and visit HPfid for that and look for a notification. But small groups have a duty to be, it's crowdsourcing. We need the whole country to say, get gag clauses out of healthcare, because then the transparency will reign. It'll make its biggest impact. The employers that are larger and self-funded, they're going to have a chance to really harvest savings more so than those that are fully insured. But everybody has a duty to unanimously tell healthcare, get the gag clauses out. And that's the most important thing they can do.
So some employers have really started trying to do things probably with different elements. Maybe they've adopted a transparency tool. Maybe they've signed up for Healthcare Blue Book, or they've, done this or that. There's a couple questions in there that basically says, isn't that enough? Doesn't that satisfy my duty? So again, hey, Tony, I'm gonna put my neck out there and see if I'm right. Yes, those activities are good, but they need to be organized, right, into a more full activated fiduciary plan and strategy. And so if you have a way to methodically go about it and organize your process and organize the documents that you've created within that process, that would altogether be better, right?
That would be better, because the key word here is, and you've hit all around, is process. The law requires a process. It doesn't require perfection. It doesn't require, like I said, the lowest cost, the lowest outcome accuracy. It has a process. If we put this in baseball terms, you know, if a ball was hit between the shortstop and the third baseman and they both just looked at it and let it go by, there was no effort, they would probably fail. But if they both, one dives to the left and one to the right, and they both just missed it, they're not going to be charged with an error. It's a base hit. You got to have a base hit. You can't come up with an error here. You got to do something, and you got to do it soon.
What I want to share maybe on top of that, Christy, is there's two different things here. So when you get your renewal information from a large entity, a PBM, a BUCA, what have you, that reporting, we call that health plan reporting, and they're sharing with you what they want you to see. Your top 20 people, your high amount claimants, your top 20 drugs, but they show you what they want. They don't show you what they don't want you to see. Data, on the other side, data is ones and zeros. It's cost and quality metrics, and most are not qualified to access and do anything with data. So you need to consider getting access to a data platform. There's an industry, a sub-industry with data platforms that warehouse this, and then have analytics on top of it, and then a data analyst. So this is it's all easy button stuff. They have a just add water solution, the market does, but I would gain access to my data, get it in there, so then next year we can benchmark in Q1, let's benchmark our PBM costs. In Q2, let's benchmark our hospital deals for our top 10 costs in healthcare. So that's that process, Christy, that you're talking about. And you can, one bite at a time, you get smarter and smarter. Are we paying the right unit cost for medical? And are we paying the right unit cost for pharmacy? That could be a goal of the first half of 2024.
All right, in our last minute, let's talk about what this process through HPfid, if we hire HPfid and we go through your process, how much does that cost?
Great, thank you. And so high level. So we have a drive-up window. We have our website, and we have you can go in, it's e-commerce. You can come in and just buy and get access to it. The one-to-one relationship there is $4,500. And with Mitigate Partners and anyone on this webinar today, you'll receive an email with a discount code that reduces that by $1,000. And you'd want to activate that in October so that you can get your runway, get your process going, but know that that is the big picture price, and you will and should be able to save 10, 20, 30x that each year with a process that it helps lead to. So that is how you buy through HPfid. You go with a credit card, jump in, you'll get an email, and you will have a discount code if you want to act soon.
Well, that wraps up, and we are ending right on the nose at 1 o'clock. I can't believe we ended on time. So good job, everybody. Thanks for joining us. We will put the recording and any questions we didn't get to, we'll answer those in a separate document and post them on Mitigate Partners website. Thanks to Drew and Tony and all the team from HPfid, and Carl Schuessler, if you want to say goodbye to everyone, that would be fine.
No, thanks for everybody taking their lunch hour to go over this very, very exciting topic. I hope your food digested well. Thanks for being with us today.